Section 35 then provides charter-like protections, a sui generis species of rights. This seems to fit the court's claim in the secession reference that Section 35 is a positive example of a long tradition of protecting the rights of minorities, albeit no explanation as to how minorities come into play as a concept. But this conclusion begs the question of what exactly happened to Indigenous sovereignty. In order to backfill this omission, the courts have either recharacterized treaties as surrender agreements or simply adopted colonial era legal fictions like the so-called doctrine of discovery by implication to diminish the legal capacity of Indigenous peoples and thereby pave the way for the Crown's unilateral assertion of sovereignty, having the effect of locking Indigenous peoples into a constitutional straitjacket that they can only leave if they are able to avail themselves of democratic institutions that were imposed upon them. Neither of these options provide a solution to the problem. Rather, they add to the troubling notion that the courts are providing the color of legality to the Crown's unilateral assertion of sovereignty over Indigenous peoples. Such a move necessarily brings us into what David Deisenhouse has referred to as a gray hole within the constitutional order. It is concerning not only because of the negative effects it has on Indigenous peoples, but also the form of sovereign authority that it necessarily attributes to the Crown. That is, the ability to declare sovereignty over other peoples and thereby dissolve their national character without being subject to judicial review. This is the kind of absolute sovereign authority that both the Glorious Revolution of 1688 and later the American Revolutionary War in 1775 were reacting against, and this rejection forms the core principles of the constitutional tradition that Canada has inherited. Simply put, the stakes of failing to teach the background of Sparrow are nothing less than a failure to teach the meaning of the rule of law. So how are we to remedy the problem? I cannot hope to provide a complete answer, but I do have a few suggestions that I think would help move legal education towards a decolonized understanding of our constitutional order. First would be a historical and contextual approach to Section 9124 of the British North America Act 1867. Such an approach would require the following minimally, in my view: a balanced understanding of the history of the pre-Confederation period as seen by the Imperial Crown, local colonists, and Indigenous peoples. A more detailed view of the post-1812 changes in imperial administration and the process of unilateral legislative devolution to the colonies that really formed the backdrop of the Second Empire and the creation of the Dominions. This must include the legislative history of the precursors of the Indian Act, for example, the Gradual Civilization Act, the Gradual Enfranchisement Act. This should also cover the rise of scientific racism in the 19th century and its use by key British constitutional thinkers such as John Stuart Mill, and its continued use in jurisprudence, for example, Kagama, St. Catherine's Milling, Syllaboy. Next, a principled common law legal analysis of what 9124 could possibly mean given its historical relationship to Indigenous peoples and with the Imperial Crown at that particular moment in time. This should involve a review of Chief Justice Marshall's decisions in Johnson v. McIntosh, Cherokee Nation, and most importantly, Worcester. A clear review of the decision of Chancellor Boyd in St. Catherine's Milling and its continuing implications. This review should show his explicit use of the savagery thesis and the endorsement of his reasons in Lord Watson's decision. This should include a history of the cases that explicitly maintained this colonial approach until Calder in '73, and how this legacy continues on to this day in the problem of how Indigenous sovereignty is explained away. A good way to do that would be to use Professor McNeil's book on exactly that case. Second, a principled account on the basis and meaning of the honor of the Crown. Such an approach, in my view, requires the following. The basis of the honor of the Crown begins with the assertion of sovereignty. This is uncomplicated. It's already in the case law. Second, the trust-like relationship is not paternalistic. This is properly understood. The honor of the Crown thus reflects both the fact that, quote, the relationship between Indigenous peoples and the Crown is one of equal partnership. That's from RCAP. And that Indigenous legal traditions are among Canada's legal traditions. They form part of the law of the land. It's from a recent federal court decision. Next, Indigenous peoples and the Crown share sovereignty. The concept of shared sovereignty was endorsed by RCAP and also has been picked up by the courts. In sum, the honor of the Crown recognizes the impact of the superimposition of European laws and customs on pre-existing Aboriginal societies. That's from McLaughlin's dissent, and it's cited with approval in Manitoba Métis. And this should respond to the colonial practice of assimilating by imposing a heavy obligation on the Crown to reconcile with Aboriginal peoples as equals in confederation. The substantial meaning of this equality is based on the fact that the assertion of sovereignty must be reconciled with the fact that Aboriginal peoples were here first, they were never conquered. Thus, the terms like occupation of land, trust-like, cannot be understood as diminishing the status of Aboriginal peoples as sovereign peoples. To do so would be to conflate partnership with assimilation. 3, I believe that the secession reference should be taught in conjunction with Sparrow via a problem-based approach. So such an approach should require the following. The practical limitations of the Sparrow framework should be unpacked. The Sparrow framework has not facilitated a process of constitutional negotiation. Instead, by viewing Section 35 rights as being analogous to those in the Charter, it has placed the parties on unequal footing. The fact that unilateral infringement remains possible has led to a situation where the Crown engages in consultation with the resources to litigate to achieve its policy goals, whereas Indigenous peoples have had to spend many years and considerable resources litigating to simply prove how these rights continue to exist. In other words, consultation and litigation have taken the place of honorable negotiation, and this has resulted in a situation wherein, to borrow the words of Justice Brown in Mikisew 2, the burden of achieving reconciliation is thereby placed upon the one group of Canadians whose assertion of sovereignty is not what demands reconciliation with anyone or anything. And finally, the secession reference shows that there is a coherent and principled way to move forward from Sparrow's charter-like rights to a jurisdictional understanding of Section 35. The secession reference provides a basis for a negotiated resolution of outstanding issues because the court in the secession reference recognized that it was dealing with a jurisdictional dispute between, quote, the initial members of Confederation who were involved in the act of, quote, nation building. It applied the tools appropriate to that circumstance. The problem in the secession reference is that Indigenous peoples were categorized, because of their cursory view of history, as a minority within Canada, and their contribution to the building of Canada was thus diminished without explanation. But this error can be remedied by rejecting the colonial understanding of the fiduciary relationship between Indigenous peoples and the Crown. Once the relationship is seen in the correct light, it is clear that Indigenous peoples are also initial members of Confederation who are involved in an act of nation building. The model of reconciliation put forward in the secession reference honors the Indigenous-Crown relationship by requiring negotiation to maintain the legitimacy of the constitutional order. In contrast, in Sparrow, the court recognized the Crown's claims to a colonial conception of sovereignty that diminishes the legal standing to Indigenous peoples to that of a cultural minority. The Sparrow model of reconciliation begins with a constitutional imbalance that cannot be explained and can only provide an unbalanced negotiating table. It leaves us basically with what Justice Binney referred to as law office metaphysics. A lot of hand-waving, not a lot of thinking. By bringing the principles of the secession reference to bear on Crown Indigenous disputes, the court would impose the duty to negotiate outstanding claims based on the honor of the Crown, a duty that takes unilateralism out of the toolkit of all the parties and requires the conduct of the parties in such negotiations to be governed by the same constitutional principles that give rise to the duty to negotiate, namely federalism, democracy, constitutionalism, the rule of law, and ironically enough, the protection of minorities. Thank you.
Thank you, Joshua. The three presentations are pretty closely knit together. So what I propose, unless I hear otherwise from any of you, is to just continue and park questions until the end. Although I do want to share one thought that I had with Joshua's presentation, and that is the distinction between foreground and background. And I don't use that distinction, but I'm thinking now that I hear it that I might. I typically use the word frame and how issues get framed and what's inside the frame and what's outside the frame. But foreground and background from a pedagogical perspective is interesting in the sense that there's two containers of sources and law and norms. And the first is what we typically study, and the second in the context of Sparrow is what Joshua identified. And the foreground can be expanded or contracted to include more of the background or exclude more of the background. And the relationship between the foreground and the background, I think, is useful. And it's another way of distinguishing what the earlier panel was talking about in terms of discourse between settler law, colonial law, and indigenous law, Canadian law, because there's a bit of everything in both the fore and the background through a lot of the constitutional problems. Okay. Is Naomi here? I don't see her on the screen.
I am now.
Great. Hi.
Hi.
Naomi Metalik is a professor at the School of Law at Dalhousie University, and she holds the chair in Aboriginal Law and Policy. She was Michelle Basterash's law clerk several years ago. And she is most interested in writing about how the law can be harnessed to promote the well-being and self-determination of Indigenous peoples in Canada. Over to you.
Thank you very much. Gwe Wildasi Begisin Giskuk. I'm very happy to be with you all today. I'll try to keep to my time as indicated. And in fact, Josh made my first point in terms of teaching about federalism and Section 9124. And my first point was to make the link between 9124 and Section 35 through drawing on Sparrow. So thank you, Josh. I don't have to do that. But yeah, in my view, I submitted a paper, a judgment, a quote unquote judgment, and I'll talk about that more in a second as my reading for this. And I'm gonna talk about some of the concepts. I'm not presenting it as a paper, but just some ideas about how I think and teach around, I teach constitutional law as well, and how I teach this. But I do see, as Josh said so well, Section 35 and 9124 as intimately intertwined. And it's the erasure of Indigenous sovereignty or self-government or Indigenous legal orders, however you want to frame them, from the interpretation of both of those provisions, which is what when I think of a colonial Canada or decolonizing, I think that that's the main project. And in the judgment that I submitted to you, I tried to write it as follows, that when it comes to the constitutional division of powers between the federal and provincial governments, the jurisdiction of Indigenous peoples or Indigenous nations is the other side of the coin. The interpretation of the Canadian Constitution as dividing up all jurisdictional space as between only the federal and provincial governments leaves obviously no jurisdictional space for Canada's Indigenous peoples and effectively erases their inherent right to choose their own destinies as peoples. So before I get into some of the approaches I take to trying to teach con law, and we teach it in second year at Dalhousie, I want to talk a little bit about the collection that I referred to that my judgment comes from. I'm very excited about it. It will be coming out later this fall as a special edition of the Canadian Native Law Reporter, and it's entitled Judicial Tales Retold, Reimagining Indigenous Rights Jurisprudence. I know Sonia's on the phone. Yes, Sonia, we stole the idea of the Women's Court. A collection of us at an IBA a couple of years ago decided we were going to rewrite some key Supreme Court of Canada decisions, not just on Section 35, but on that impact Indigenous people in a significant way. We started out as 10. There are 9 decisions that we have, and it's a collection of Indigenous and non-Indigenous scholars, and some of them are on, I know they're watching this. Yeah, it turned out to be a really exciting project, and it was Larry Chartrand and I who organized the workshop, but Kent McNeil stepped in halfway, and he really helped carry this project through as a co-editor. So his contribution was invaluable, so I'm really thankful of that. So it's 9 judgments that are not all exclusively about Section 35. I have mine about nil 2-0, so on Section 9124 decision. Sage Henderson writes a lot about treaties and pre-colonial instruments. And there are definitely some Section 35 cases, but also Hadley Friedland writes about Racine and the best interest of the child concept and attachment. And I guess what's so fascinating and why I'm bringing it up about the project is that we didn't give anyone any instructions about the direction that their judgments ought to take, but there's a clear theme that runs throughout every single decision in that collection, which we found remarkable as editors, and that they all argue for the acknowledgement and application of Indigenous sovereignty, jurisdiction, and laws. No matter what decision was rewritten, that theme ran through all of them. I find that really remarkable. So I think it will be, and I intend to use it as a teaching device for having students to read as a sort of a counterpoint to some of the decisions that we have to read. So I teach both Aboriginal law and con law, and I have to say sometimes I find it pretty bleak when just teaching the cases on their own. So I think Josh is correct when he says, you know, we have to teach it in this, you can't just teach the cases as they are and teach them the frameworks without interrogating and criticizing those frameworks. So the way I think about it and the way I've sort of written my judgment in the piece, writing about Section 9124, is I try to teach about the frameworks alongside arguments and instruments that students can then use, I would hope, to harness and argue for new interpretations of both Section 9124 and 35. And you know, in doing so, I really emphasize that, you know, interpretations evolve, and, you know, the living tree, progressive interpretation. I also often will invoke the Bedford test about when we can overturn precedents. I know Brenda's written about that as well. And so when I teach my students, I try to kind of put things in sort of 3 categories of these additional instruments or arguments for trying to find new arguments for pushing 9124 and 35. And I'll put them in 3 buckets for you: old tools, new tools, and harm. And I'll just talk a little bit about it. I go into it more in my judgment for you, but the old tools would be some of the things that Josh were referring to, and what, you know, people have written about, like John Burroughs and Sage Henderson, and Josh also writes about this, but, you know, the concept of treaty federalism. So in that teaching, you know, that the first 200 years of the interactions between Indigenous peoples and colonists was primarily represented in a sort of a nation-to-nation relations, as RCAP has called it. I teach about the pre-Confederation treaties, the Royal Proclamation, the Treaty of Niagara, along with the Royal Proclamation, and I think that's really significant, as well as teaching about the two-row wampum belt. And John's article about the Treaty at Wampum at Niagara, I think, is a fantastic article to use. I try to explain to my students that, you know, the arguments for treaty, that 9124 did not have to be interpreted as it was, as giving essentially the federal government plenary jurisdiction over anything related to Indigenous people, that we could have had a different outcome. That was possible by giving it a treaty federalism interpretation. And yeah, point to the writing of peoples like Sage and John, and Bruce Ryder's also done a little bit of writing in the early 90s on this. And of course, as Josh pointed out, I mean, you need to explain that we took a wrong turn, of course, at St. Catherine's Milling for about 100+ years. And as well as that, teaching about the Marshall Trilogy. So that comes into it, teaching about, that's where we brought in the doctrine of discovery. And, you know, later when I get to Calder at some point, explaining that we just, you know, went with Macintosh, the McIntosh decision without really even getting, you know, into the Worcester decision. So Josh has already talked about that, but I try to set up all of those things as well for students to consider in their interpretation or arguments around Section 9124. I also focus on harm. And one of the other decisions in our collection does this as well. Hadley Freeland, when she's writing about the Racine decision. But I think it's actually, and it leads into some of my new arguments, my new tools. But I think it's quite important, and I do this in my judgment, unpacking the harm that the denial of Indigenous jurisdiction has caused to Indigenous peoples. And so talking about decisions that have, you know, not only recognized plenary jurisdiction to the federal government, but effectively recognized concurrent jurisdiction to the provinces. Dick, Kitkatla, more recently Chilcotin, Grassy Narrows. I mean, the blurs the line between jurisdictions so significantly and just allows for virtual concurrence. And that kind of continues on in the spirit of Section 88, which is also problematic. And I also will teach a little bit about Section 88, and it was kind of intended as a means to sort of give jurisdiction to the provinces unilaterally by the Fed, so that they could address essential services, and so the Feds wouldn't have to foot the bill for this. So, and that's based on some of my other writing. So I try to explain, you know, some of the harm that is caused by taking this sort of concurrent approach, I would say, and John has written about this as well, but I write about how, and I try to talk to my students about how these approaches have, you know, led to both an equal amount, I would say, of assimilation and neglect. And so pointing to the Indian Act and residential schools as examples of the harm of assimilation, but also the harm of neglect. And that, you know, the complexity and how the courts have added to the complexity around jurisdiction have allowed for this sort of hot potato interjurisdictional neglect to happen with respect to some of the most important services, and not only services, but also justice issues relating to Indigenous people. So underfunding of essential services, a complete lack of recognition of Indigenous jurisdiction and laws, and how that translates into the poverty and the overrepresentation that we have seen in both the child welfare system and the criminal justice system. So I actually think it's important to situate that harm, and we don't maybe often talk about it, but I see it as so fundamentally connected to federalism and how we have interpreted the Constitution. And so that leads me into why I then, my last bucket, which is new tools. And I try to, you know, say that there are, in addition to the treaty federalism arguments, there's all kinds of stuff in recent case law that we could point to that suggests that we ought to be interpreting 9124 in a different way. So Josh has already talked about the secession reference, but certainly the concept of federalism and how the court expanded on it in Spray Tech. I think that the concepts there really support, you know, a multitude of governments operating on an equal level. So, I mean, there's that. I also point to Section 15 and Section 7, and some people might disagree with me on that, but, you know, I think that and I often will talk to my students about what I think is a watershed decision, the Caring Society case, where, you know, the Canadian Human Rights Tribunal talked about the concept of substantive equality as, you know, being about meeting the distinct needs and circumstances of First Nations children and families, including recognizing their cultural, historical, and geographical needs. Now, I know that's just a tribunal decision, but it's consistent with several decisions from the Supreme Court about what substantive equality is. Such as some cases in the Francophone context, and more recently, they said something to that effect in Ewart. I think that, you know, this concept of substantive equality has a sort of could have a collective element to it in recognizing sort of cultural difference, but beyond that, also recognizing some self-determination. And there's a great quote I read in one of Bruce Ryder's early papers, where he actually cites Justice Pigeon, who wrote an article in 1951 talking about Quebec sovereignty. But he wrote how autonomy is the right to be different. But when I think about substantive equality, it is also the right to be different. That's exactly what substantive equality means. So there's a link between autonomy, substantive equality, and that I think is that we could do more with. And On top of that, of course, coming back to my discussion on harm, you know, I think there's some work that we could even do around section 7 and the missing and murdered and national inquiry actually said that interjurisdictional neglect and this sort of hot potato of tossing Indigenous issues back and forth actually is a violation of Indigenous women and girls Section 7 rights. So I do think that there are arguments in our charter that we can marshal to sort of say we need to be thinking about our jurisdiction very differently. There's reconciliation in the honor of the crown. I see my time. I'm getting close to 14 minutes, so I'm going to wrap it up. But I think that there are arguments that we can certainly make with how the court talked about what reconciliation is in Daniels, that it's something that Parliament always has in mind. And I would think that, you know, if we always have in mind, we shouldn't adopt interpretations that essentially perpetuate assimilation. So there's a few other things I say in the paper, but you can read that. And I also talk about the presumption of conformity with international law and the principles that support that we should be reading our constitutional documents in line with international documents. I know we have Brenda on board coming in a moment, so she'll do that talk. But I mean, I think you can marshal all of those things, and when you put them all together, I think they make a really compelling argument of, you know, really questioning how can we still interpret 9124 this way or 35 this way. And that's it. I'll leave it there. Thank you.
Thank you, Naomi. That was thought-provoking. And thank you for continuing to keep jurisdiction a running theme of this panel. We'll come more directly, I think, to Section 35 in a minute. One challenge that I confront teaching 9124 and 35 is not so much clearing the ground for some kind of constitutional legitimation of Indigenous laws, but having the ground cleared, then what do I talk about in terms of what does it mean to conceptualize Indigenous jurisdiction? And I guess partly out of prudential reasons, given my lack of knowledge of Indigenous law, I don't delve that much into it. But the students, I feel, are left with a sort of tantalizing void as to, well, this all sounds great, but what exactly is this going to look like? And one thing I took from Naomi, I've been doing some work on this topic myself this summer, is that pedagogically we might want to, some of us might want to pick out one particular area that's vivid and concrete. And there's a lot of background material for it. Following knowledge is a great little case because the students see what's exactly at stake, which is the legal matter. But if we were to focus a little bit more deeply on child welfare as a jurisdiction that is contested, there's a lot of background material for that too, with the various inquiries. So the more concrete, this is what I'm taking from Naomi, at least for me, the more concrete you can get without treading on the uniqueness of Indigenous law, I think the better for pedagogy. Okay. Our third speaker is Amy Kraft, and she's a professor of law at the University of Ottawa and an Anishinaabe Métis lawyer. She's from Manitoba. Amy works in the area of Indigenous laws, treaties, and water. And she's done a lot of work and research on Indigenous relationships and responsibilities to water. And some of her work involves visual arts and film. And she's working also in relationship to transformative memory in colonial contexts. Welcome.
Great, thank you. Bonjour, ndine maganak kiwin no dine kwengish indishibas mekanaki kwimishibas. Again, hello them. I'm joining you from Treaty 1 territory, from Saging. So Saging, the mouth of the river, is actually just behind me. And I didn't put my earphones and speaker in because I thought maybe you would hear the waves and the beautiful rain that's falling now. It might also mean that if the thunders come, that we might lose power and I might have to find another alternative way to join you. I wasn't really expecting this, this rain and this little bit of a storm today, but it's really nice to have it here. And I think it's emphasizing actually a lot of what we're talking about, which is tumultuous, stormy, uncertain circumstances of teaching Canadian constitutional law, thinking about Indigenous constitutionalisms in relation to that, and decolonizing our practices of teaching. I thought about, kind of anchoring this in a paper, and I did share a paper that I wrote on reconciliation and sort of the cloudy misunderstanding of the terminology of reconciliation and how it's applied by the Supreme Court of Canada in the jurisprudence as really a framework of justifying infringements of rights. But I think what's most useful, what I'm hearing from the questions, I think is to delve into how we teach and how that can actually impact the more, it can be the most impactful in terms of decolonizing practice. So I teach Canadian constitutional law, I teach Canadian Aboriginal law, and I teach Indigenous legal traditions as part of my teaching complement. For those of you who are doing the math, this year I'm in overload. I'm also teaching a water law course. But it's kind of fun to navigate back and forth between those and the teaching methodologies that what I may not have done, I may not have employed as a technique for teaching and method for teaching in first and second year too, Naomi, constitutional law, division of powers in Canadian Aboriginal law, but I may not have employed in that sort of more structured cours magistral kind of lecture style. I've now started to think about how we can use Indigenous methodologies and decolonizing methods to try and learn Canadian constitutional law within that classroom context when addressing division of powers and Section 35 within that like Canadian constitutional law course. So what I was thinking about in preparing comments for today and picking up on some of the conversation is what we teach is just as important as how we teach it. So if we take a holistic approach, we're thinking about both in any effort to decolonize our Canadian constitutional classroom. And part of how I came to that was thinking about what I've constantly heard from the elders that I work with within our territory, so Treaty 1 and Treaty 3 territories, where they're asking us to think about law not as a theory, but a practice. So how do we embody that in a classroom, and how do we think about decolonizing the classroom space when engaging with constitutional law, whether it be Canadian constitutional law or Indigenous constitutionalisms? And I really appreciated the first panel and also Josh and Naomi's comments, as we kind of lead up to this idea that I want to introduce. So I think methodologies of teaching are essential for decolonization. And that means that we need to take seriously a few things. The first is equality of voice. And so I bring the methodology of a talking circle into the group. So it's not sort of solely focused on the expertise of a professor or someone who's communicating material to be absorbed, but it's an engaged, equal atmosphere. And I think that that brings out a lot more learning in terms of critical studies and decolonizing practice for the students that are participating in this learning. It also engages a deep a rootedness in positionality. And I think Jeff Hewitt has already talked about this idea, and so has Darcy Lindbergh, is situating the students within their own context and understanding where they're coming from in terms of their previous learning, their preconceptions, their misconceptions, what they have yet to learn, and being able to address that head on, and thinking about own voice as an important part of this sort of equal voice and positionality that is part of a decolonizing methodology for teaching constitutional law. I think it also means being attentive to things like gender. So, and this is not a critique, David, but I noticed that the first panel were 3 men that were speaking to Indigenous legal orders. And I kind of regret not having volunteered for that panel, because I think in all of the things that we do, we need to be attentive to the different voices that are coming onto these conversations and mediating those spaces in very important ways. And that's a huge responsibility as law professors. So I think that those are really important things to think about in structuring a decolonial classroom. I think that the second point in terms of methodologies bleeds into a bit of the substantive, but making sort of dedicated space to assess the limitations of Canadian law. So thinking about Canadian constitutional law not only as something that we teach as though it is a fixed state, because we know through the understanding of constitutional law itself that it's an evolution, but thinking about the opportunity for critical analysis while learning building blocks. So I know that there's different views on pedagogy where you would introduce concepts and then do critical analysis. I actually reverse it and think about critical analysis as being the building block for understanding some of the constitutional concepts that are essential to the students learning through the term. So those are the first 2. I think there's also, and I take Erin Mill's point seriously in terms of, you know, what is the role of Indigenous law and Indigenous constitutionalism in this teaching, and also the idea of conflict of laws and contrast. But I think that there has to be, in a decolonial legal pedagogy around constitutionalism, some space for engaging with Indigenous legal responses. And so I say that very broadly in terms of Indigenous legal responses as including, you know, concepts of inherent legal responses that are rooted in Indigenous legal orders and traditions, to very pragmatic approaches that are grounded wholly in Western legal systems and Canadian constitutional laws, as all being part of this broad slate of Indigenous legal responses to problems that are posed within a constitutional context. So in that, I think that there is also a secondary space on regionality, and I really appreciated what was being said by Darcy Lindbergh in terms of focusing on Treaty 6 within his particular context. And in our constitutional or Canadian Aboriginal law class this term, we're going to be focusing on Algonquin claims to territory within the Ottawa General Region. And I think so regionality is important, and thinking of different ways to incorporate that, and also thinking about how Indigenous legal responses are going to vary depending on those contexts, including regional contexts. So if you're coming from a territory that is anchored in historic treaties, then you're going to have a very different understanding of what types of legal responses might be available, what types of legal responses are appropriate given that particular regional context. And so I'm using regions very generally, and you could substitute that with nations if you wish. And I think there's other ways of thinking about those subspaces that are really important. So own voice, I think coming back to that idea and making space for Indigenous legal responses also means working through case studies as methods to understand constitutional legal concepts. So I say case studies not in the sense of studying cases, but case studies of ongoing legal problems where students have to engage critically with this whole swath of tools that have been canvassed, including critical perspectives of Canadian law, and trying to engage with Indigenous legal responses and thinking about what types of solutions or responses might be engaged. Okay, so I think those are 3 sort of really important subcomponents of methodological approaches that allow for decolonizing the teaching of constitutional law. The fourth that I would add is decolonizing spaces. And I think we heard about that right from the start from Darcy, who was saying we need to walk outside onto the campus and do this tour today, which is an excellent approach. Being rooted in land and land-based learning, I think, is one essential part of this decolonized learning. But I think that art also has a role to play. And Patrick, in your introduction, you did talk about how my practice is kind of refocused on art and video as methods for teaching and understanding Indigenous legal orders, as well as treaties. And so there are two efforts that I want to speak to specifically, and I'll try and share this. I'll share my screen. So this first initiative is a triptych series that's at Robson Hall at the University of Manitoba Faculty of Law. And what was done is, as mentioned earlier, protocols were followed, and this was a request made of a local artist within the Treaty 1 territory, his name is Linus Woods, to generate a series, a triptych, a three-part, that would describe Anishinaabe constitutionalism and treaties, and that would be used as a teaching tool. So this sits in the moot courtroom at the University of Manitoba, and is meant to be a place, a space of learning that's interpretive, that's critical, that is decolonized. And the second that I want to refer to is this mural that's about to be painted in about a week and a half at the University of Ottawa in the Faculty of Law in the Fauteuil building by artists Isaac Murdoch and Christy Belcourt. And this is a representation, and I can't do it justice in the time that we have, but of Anishinaabe, Nibianalkanagewin, so Anishinaabe water law. And this will be a teaching tool and actually a physical space, a way of reclaiming space, of decolonizing space within the faculty, but a way of accessing an understanding of jurisdiction relating to water that may not be available in other classroom settings. So I think, for example, when I teach water law, the murky jurisdiction of water, how we try and understand who has responsibility for water, and thinking about this as a way of flipping the framing and starting from Anishinaabe understandings of who has responsibility to water, and how that jurisdiction is taken up. So I know we're limited on time, so I don't want to take up too much more time, and I look forward to the discussion. I think the last thing that I would, there's actually two last things that I would like to say. On the substantive front, I think it's important to start whatever course that engages with Canadian constitutional law by unpacking terminology. And for Anishinaabe people, law is wholly centered in language. And I think that for most legal thinkers will also say the same thing, that law is centered in language and interpretation of language. And so tackling concepts, the legal fictions that arise from the use of certain terminology is essential. And in that, thinking about sort of chronologies and life histories of law. So understanding things through a generational lens. So often I'll speak about generations of interpretation of treaty and think about them as parsed out timeframes, not necessarily to think about them as, linear chronologies, but rather periods of time or generations in which a certain constitutional understanding or a certain treaty understanding was expressed in a certain way, and how things have evolved and built, that they're connected within those generations, but that they aren't necessarily fully formed. So the ability, fully formed and unmovable in sort of their longer term evolution. I think, Naomi, you made that point. We have opportunities that are even illustrated in current case law that are allowing us to rethink how we interpret 9124, for example, or Section 35. The last substantive point, the last point on sort of substance and how we think about decolonizing these spaces is thinking about concepts that exist in constitutional law that we might use for different purposes than they have been in the past. And so I've asked David to share with you a piece that Deborah McGregor and Jeffrey Hewitt and myself wrote for recent publication called Vulnerable, the Law, Policy, and Ethics of COVID-19. And it's an open source publication. And we were asked to do a short piece on the COVID-19 and First Nations responses, which we were asked to do Indigenous responses, and we said, we'll limit it to First Nations responses. And even that was difficult. So we just chose a handful of examples that reflected First Nations self-determination in the areas of health that were aimed at mitigating the spread of COVID-19 and trying to maintain health and wellness of First Nations peoples and communities, which is a legal pillar of Indigenous legal orders. So we suggested that First Nations, as the most proximate government, are best positioned to make policy and law response decisions to COVID-19, and that they should be supported financially in the endeavor by the federal government in the form of a sui generis application of the constitutional principle of subsidiarity. Okay, so where authority rests with the government that's closest to the context and to the people. So we shared that, you know, in light of continuing efforts of Indigenous peoples and nations to maintain and restore good relations, to live in wellness, which are also key pillars of treaties and Indigenous legal orders in Canada. So this is, you know, it was thinking about the irresponsibility of the federal government, which increases the risk to First Nations in a COVID context. So I'm thinking here of housing and clean water. And Naomi, you've talked about basic human rights and violations of those rights and failing to provide adequate resources to First Nations people living on reserve. So by applying that principle of subsidiarity, in conjunction with some of the other constitutional obligations like fiduciary duty and duty of the Crown to act honorably, we focused our discussion on these actions that were being taken as Indigenous assertions of jurisdiction that would have significance in a constitutional understanding of both the concept of subsidiarity, but also would help probe the value of cooperative federalism in a robust tri-jurisdictional context. So that's a mouthful, and I invite you to read the piece, but it's really looking at an application of a concept that's never been, to my knowledge, really invoked in a First Nations context, and kind of flipping it and thinking about this idea of subsidiarity in relation to First Nations in their relationship with the COVID responses. So I feel like I've shared a lot. I'm looking forward to the conversation and questions and continuing this discussion. Miigwech.
Thank you, Amy. Your discussion of some teaching aids or teaching tools led me to want to share with you that something in the very, very early stages associated with the new edition of Canadian constitutional law, and this is not a plug, but the idea is to try to take advantage of the fact that a lot of us are taping sessions for classroom use, and put together a teacher's workbook or manual that would include links to tape videos of the editors teaching various aspects of the course. So at one point you might tell your class, well, let's listen to hear what Jean Leclerc has to say about the unwritten Constitution and its successive reference in Section 35. You just push the button and you have 10 minutes of Jean Leclerc, and then you come back and then you can debate Leclerc's position with other positions that you've taught yourself. So that obviously could be a complicated project, but it might be something may not occur within the confines of this casebook, but it's something, just looking at all of you on the screen right now, being able to access your Hugh's 5 or 10 minute take on a particular point live in class would be quite an extraordinary thing, at least I could say. So I just wanted to put that on the table and as another possible set of procedures. Let's open up the discussion. I'm not sure how people signal to me, but I guess that will become clear pretty soon. Comments? Federalism, jurisdiction, sovereignty.
People can raise their hands.
Literal hands. Ah,
There's a raise hand function.
okay. We have Carrie.
Sorry, clicked the wrong button. Thanks to all of you for your presentations. I'm grateful for them. I think my question rephrases something Patrick was getting at in response to Naomi, but he can correct me if I'm wrong about that. Let's take for granted that Indigenous sovereignty exists and survives in Turtle Island. Given that, is there an ongoing role for Canadian courts in dealing with matters involving Indigenous peoples? And if so, what's the nature of that role?
I guess that's over to me first, right? So here, I'll put my camera on. And I think that'll give me a chance perhaps to also respond to Patrick's comment, I think about, you know, some of the comments sometimes that he might get from students about concerns about a void of sorts, a tantalizing void. And I think that that's a concern sometimes that judges have. But I do think that, you know, there is some amazing work, and I'm sure we'll hear from John, but that is happening throughout the country. I mean, so many of the people who are presenting are doing phenomenal work with revitalizing of Indigenous laws. I do think there's lots of work that needs to be done. I have started my PhD at the U of A on specifically the questions that will be coming up about, well, you know, what happens if there are these laws? How do they interact with Canadian laws? What if there's a conflict? What do we use? Do we use paramountcy? Do we use Section 35? Do we use private international law? I think there's a lot of questions, and I think that there's some the burgeoning scholarship on those questions, but they're not all answered yet. But I think it's time for us to start unpacking them. I don't think they're insurmountable. And in my little piece that I wrote in my collection, I talk at the end about judicial courage. And I do think that sometimes we use the fear of what people think might be a void, and there isn't a void. Indigenous laws are there to fill the void. There's work that needs to be done in figuring out a lot of questions, but they're not insurmountable, and we don't let other questions, you know, the courts address things incrementally. But to come to your question specifically, I mean, I don't know all the answers to that. There will be questions where there's going to be overlapping or intersecting law. Some people talk about it as intersocietal law. And, you know, there will be questions about what role do the Canadian courts play? And if they do play a role, what are the limits on their intervention? And so we are seeing there's a few great cases that are coming from the federal court. Justice Sébastien Gramont has written some of them about, you know, giving deference in situations where we're dealing with Indigenous law or self-government, so the courts are not intervening significantly. So that's a really interesting development. So I don't think we have all the answers, and I think that there will be situations where Canadian courts may still be called upon. And there's you know, you know, there's people who say, well, we don't want Canadian courts dealing with Indigenous laws at all. But you know, it may well be likely that they will. But I'm hopeful that we will start develop principles that will help us in trying to mediate that. So I don't have the answer. I just have an idea of where we might be going. Perhaps my colleagues want to add on.
I'm happy to jump in if I may, or Maida, would you like to first?
Sure, I'll just say something
Yeah,
very
sure.
quickly. I think, Carrie, the response to your question depends on the context. So I think disputes between the Crown and Indigenous people being mediated by courts is a very different context where within the authority and inherent jurisdiction of a nation in an internal dispute, there may be a decision to appeal to a court as a body that could assist with the resolution of that dispute. And I think that we really need to be mindful of which context. So if we're talking about disputes between the Crown and Indigenous people, I have the same concerns that have been raised over and over again about having those disputes mediated by a construction of the Crown itself, right? But I think that there's opportunities like what the federal court has done with mediation as a tool that's offered by the court, where you're not subjecting the dispute to the final authority and decision making of the court, but rather that the court is a tool to assist parties in coming to an appropriate resolution. I think that that is an appropriate and possibly expanding role for the courts, as I see it. That's just a brief response to that question, but I think that distinction is an important one.
I'm happy to follow up on that, and I understand the spirit of Carrie's question, wanting some pragmatic guidance forward in terms of institutional design. But as often in Carrie and I's dialogue, I like to go back to the problem of the status quo and really the nature of the problem that we are facing within common law constitutionalism. I think there's far too much comfort putting the as if over top of Indigenous sovereignty and like, well, let's consider what would happen if we did this, without really a clear awareness of where we are in the sense of recognizing a form of Crown sovereignty that doesn't cohere properly with a common law tradition of rule of law. There's good scholarship on this. Ernest Frankel's work on the dual state, analyzing exactly how the National Socialists were restructuring the Weimar and the tensions that existed there. Like the Jurisprudence of Power book on the Morant Bay Rebellion by Coastal, Deisenhouse's reaction about that book and the puzzle of martial law. This unpacks the same situation that Canada is in. Those same analytic frames can be applied. And really the Hofeldian point of, if you allow the Crown to diminish and the court gives the color of law to that action, Indigenous parties, to the as if, well, then you've just empowered the Crown by necessity. You've given judicial recognition to a prerogative power of the Crown. And explain to me what that prerogative power is and what it entails. This is the Burkean worry, right? The Burkean worry that the law of the empire and the idea of the king's domain would undermine the legitimacy and stability of the English constitutional order. And until we come to grips with that, then we're just operating in the frictionless space of concepts with an idea of epistemology that locks it back to causation, which is frankly like bankrupt in philosophy. And we need to stop talking about that kind of stuff. We need to face, in all honesty, what we're here to deal with and the nature of the crisis as a constitutional crisis, and then go into the problem of institutional design, not as a maybe we should morally, but maybe we should immediately, because otherwise we have empowered the executive in a way that is destabilizing the West. And we can see that now.
Can I just rephrase a little bit? If we think about Indigenous sovereignty, should we then think about it as a feature of Canadian constitutionalism, or, and here I think I'm following something what Aaron said, as a feature outside of the reach of Canadian constitutionalism?
I don't think necessarily outside of the reach. I think that there are models, you know, and I mean, you know them well, the examples within the Canadian case law where recognition is given to Indigenous law and jurisdiction, and understanding the role of the courts. I think really, like for me at least, the best judicial articulation of what the role of the courts are and how they are to relate really comes in Chief Justice Marshall's decision in Worcester, and the emphasis that whatever we're doing here, the way we're interpreting this treaty, we can't do it in such a way that would annihilate the national character of the Cherokee. He recognized that if we do that, I've empowered the sovereign in a way that I can't tether him back to a rule of law jurisdiction, right? There are lots of solutions that we can hit on the table in terms of how to do it. And naturally, the court is not going to be, in its current structure at least, you know, like having Indigenous membership required, right, on the body of the court, having indigenizing the Senate and turning it into something that's not a joke, would be nice. There's lots of things that can be done, but I just don't want us sticking in this, like, I have no idea what to do, and sitting in a boat with holes in it that is sinking and acting as if, and I know that you're not saying that, so I don't want to come across as like reading the riot act to you. We've had a long and enriched conversation. And Carrie did me the honor of looking at my book and giving me detailed comments to react to. So whatever positive qualities the book has are in large part due to Carrie's contribution to that. But yeah, I just want to keep hammering that point, and then I think we can get clear-headedly and pragmatically to the problem of redesigning institutions. And we can go and look at Aotearoa, which I always mispronounce, but you know, New Zealand in brackets, and start to look at an institutional design with some real eyes. But I really do want to attack the idea that we can just sit status quo and consider whether or not we should.
Okay, let's see if there's another round of questions. Anybody want to participate? Okay. Amy?
Patrick, my screen says that there were 3 people raising hands, but maybe that's now gone. I don't know. No? Okay.
My screen says Vanessa McDonnell, Patricia Cochran, and Stephen Chaplin.
So if anybody would like to contribution, please speak up now.
It's Patricia here. I'll jump in if I may. Thank you so much for all of your thoughts. This is really energizing. I really appreciate having this opportunity. My question is I'm reflecting on sort of how to teach all of these things in the classroom, in the constitutional law program. And there's a tension that I often feel between, I don't know that it's a real tension, but one that presents itself for me in the classroom for students. And that's on one hand, trying to use the tools that we have, for example, the idea of the rule of law, and to help students see where those cracks are in the colonial legal order. And I'm, learned a lot from Josh, your work on this about, helping people understand that those are not kind of details in working out. These are like problems where there are concepts that are in tension with each other that are not living up to their own potential for institutional design. So doing that, things like helping people see if we actually follow seriously the rule of law, where do we go? And then on the other hand, allowing the tension to exist, which we talked about earlier, and not going from that, because I find sometimes it's easy to get students to see the conflict, but then what they want to do is resolve it. I would be really interested in anyone's thoughts on how you keep both those things alive in the classroom.
One tool that I use often is modeled positionality. So placing students in different characters and having to advocate or resolve a problem from that perspective. And there are some that resist that. They always want to be in sort of one role within the thinking through a problem. But I think that's actually a good practice for people that will be entering into practice as lawyers at some point in time, right? So thinking from the other perspective. I've found that's been really effective. And I've had students that have actually said, I think I'll be better able to deal with lawyers on the other side, having had the opportunity to try and think the way that they do. Others find it really hard, but I think that it's still very worthwhile for all of them. So that's one idea.
Naomi, did you want to come in first, or?
No, I guess all I'll say is I echo MA that I think that giving hypotheticals and working through and considering all sides of things and practicing other positions, I think is a really good suggestion. That's it.
I think like my preferred pedagogical approach is to use Freire's pedagogy of the oppressed and also Dewey. To try to do a problem-based approach. And so I think that comes with the humility of acknowledging that in order to try to create a leveled classroom where we're all addressing a problem from different perspectives, that whatever tools we come up with are going to reflect more our own skills and backgrounds and stuff like that. But I think trying to get them to see that like their idea of what law is matters, that it's not something that arrives from the ether in the form of legislation, that actually legislation without a background of common law practices would be incoherent. It would look as silly as like Humpty Dumpty talking to Alice saying that he can define what words are and that what they mean. I think that really like shaky view of positivism has been largely dismissed. And I think really unpacking it and showing them, no, like actually how you live and practice law every day and your perspective of what it means and all these concepts, they matter. They're not banked in your professor's head and then transported into yours so you can walk out there like a bunch of robots. That's just not how it works. However you'd flip the classroom and then doing it in an authentic way, like that's an ongoing experiment. Like I try to like talk at them and then say like, by all means join, but I'm not going to name you, because once I name somebody and get them to talk, I'm forcing them to talk and I'm using my authority in the room to do so. So I don't know, it's an uneasy navigation for me as well.
Okay, well, we're in good hands because the next panel is going to answer all those questions for us. And Joshua, Naomi, Metallic, and Minecraft, thank you very much.
Okay, before we break, let me thank the panelists again and you, Patrick, for moderating. Another stimulating panel. I was prompted to think, though, principally by Josh, but not exclusively, also by Naomi and Amy, that you're proposing to us that we reconceptualize how we go about teaching this course. And you're bringing cases together that we might not have thought of bringing together. So I'm wondering whether it'd be worthwhile to offer up to anybody who's interested to send me their syllabus. And I wonder if we could use the Decolonization website as a clearinghouse for syllabi, and then we could better, I think, incorporate some of the lessons that you were trying to teach us over this session. So I'm just offering that up as an idea because it's going to be difficult, I think, for most of us to think about and reimagining how we might reorganize what is a course that's rooted in 19th century federalism, in which we've glommed on a charter in Section 35, and how can we reimagine it in ways to improving it, making it better, and decolonizing it. So thank you again. I'm going to keep the Zoom conversation going. I'm going to stop the recording. So if if you guys want to chat, please do. We'll be up again at 3 p.m. Okay? Thanks, everyone.